Shell and Impact Oil and Gas have lost their appeal over exploration rights on the Wild Coast. The Supreme Court of Appeal dismissed the majority of the companies and Energy Minister Gwede Mantashe's appeal bids. This upholds a previous court ruling that deemed Shell's exploration rights off of the Wild Coast as unlawful. Tauriq Moosa, who's legal writer for Business Day Editorial, joins us now to unpack the SCA's dismissal of Shell's bids. Tauriq, always a pleasure and a good afternoon to you.
Good afternoon to you.
All right, Tauriq, maybe we can go back with this. It's actually been a back and forth, hence we are in the Supreme Court of Appeal now. Just take us through how we got here.
So this is a result of several exploration rights that Shell and Impact obtained several years ago, and it's been renewed numerous times. The main so what they were doing is known as seismic blasting, which is what they do. They've done it off the Wild Coast, and also a similar company did it off the West Coast several years ago. And what they're doing is they're saying that they're trying to explore for oil and gas, which they do by blasting these gigantic speakers on the floor bed. And the decibels exceed even that of a jet engine, so it can destroy human ears, but obviously it has an impact on fish and wildlife in the ocean. The important part here is that Shell and Impact, when they do this, it impacts the small-scale fishing communities that are dependent every day on the fishing lines that are there, that they've known for generations. The problem in this case is that, according to, and as the High Court and now the Supreme Court of Appeal have agreed, the process to get those fishing rights and those exploration rights was done in an unlawful way. Primarily it was as a result of improper consultation. So when companies want to explore, they have to go through a rigorous environmental process, and part of that is notifying affected parties and affected people. In particular, in this case, in the Wild Coast, they were supposed to notify several villages and small-scale fishing communities, but they did not do so. They claim they did so via issuing memos and notifications in English and Afrikaans. The problem, as the court and as the fishers highlighted, is that those languages are not spoken very widely there. There was also no proper radio announcements, and as a result, the court found that there was no proper notification, and if you fail a notification, everything else falls away and it's unlawful, and they should never have been granted that right in the first place.
Now, what's interesting here, of course, is the fact that it seems that there is just a big part of contention here between issues of development and then the environmental impact here, Tauriq. And I'm wondering if we shouldn't have laws that are more clear, or if matters like this are bound to cause some conflict and can only really be sorted out on a case-by-case basis.
So that was exactly what led to a sort of mass moratorium on exploration rights, which is what is currently the case. So you had all these companies that attempted to pass through these processes, but kept failing because of these complications in terms of the processes. And the environmental laws have been somewhat confusing, and it's a result of high court cases that they've slowly started clarifying and correcting regulations and so on. But of course, all of this is dependent on government itself creating the legislation and laws. And as you can see, one of the parties in this is, in fact, the Minister, Gwede Mantashe, who's responsible for sort of environmental laws and hasn't, and himself was supposed to adhere to it and granted the license himself. So it's government that has to sort it out, which is what the court case has indicated.
I've also seen some schools of thought thinking that this would, of course, work against South Africa's foreign investment here. And I think it's also a slippery slope, isn't it, this foreign investors. The investors, actually still important today, but we're always talking about these investors and what, what their sentiments towards us will be here, Tauriq. And let's talk about that where this specific exploration issue is concerned.
Yeah. So if you look at the amount that was spent just on this, so I think it was in the region of 1.1 billion was spent on this. And what Shell and Impact both said was that, look, if we come here, both it'll encourage further investment and other companies to come explore, but also we can provide jobs and the sort of tax will go into that. However, the court also indicated that that's not sufficient. You can't just claim that just because you're going to give jobs and there's going to investment that you can override environmental laws and environmental considerations. Because South Africa has to adhere to environmental treaties, international treaties and so on, and that's of prime concern. And you can't just use investment opportunities and so on to forego that. So we ourselves set up these laws, and we ourselves have to adhere to it.
And are we getting it right? I mean, you've said we've seen this moratorium on exploration, Tauriq, and it is a matter of concern.
Yeah.
But is there work being done at the right pace? Because of course there are still investment opportunities, and if done properly, we could see a real contribution to GDP and the likes.
Sure. So I mean, what you'll see in all these cases is that the environmental activists and the small-scale fishing communities never make a case out that it should be completely scrapped. All they're saying is adhere to the proper processes, inform us so that we can inform you. So not even the environmentalists are saying that it shouldn't be done. Certainly in terms of seismic blasting, we've had evidence from UCT experts, Stellenbosch experts and so on, who've all said that seismic blasting is still too new and it's doing untold damage we won't see for several years to come. But they can't make that case out just yet. And their sole case is, here's what the law is, you haven't adhered to it, and once you have, then there might not be an issue. But right now, because of the complications with law and this moratorium, it's unlikely that this will be a smooth process going forward.
And based on the SCA now, normal appeals, is there still chance for it to go to, there's still the Concord?
Of course.
Or are we expecting that this to be it?
So the order is very strange because the SCA didn't uphold every single aspect of the High Court order. What it did say was that though the process was flawed, the court still has discretion in what remedy it grants. And the SCA said the remedy that was granted by the High Court, which overturned all of the licenses and overturned all the exploration rights, was too harsh. The SCA said instead, because the Impact and Shell had filed for a renewal last year, that should be allowed to play out. So what that means is that that whole process can start from scratch, but it can now, they don't need to start completely from scratch, they can just go from last year. And because we now have identify the people who will be impacted, like the fishing communities who are all now who are in court, that will make the process easy because now they will be consulted because we know exactly who they are. So the SCA said, though it's wrong now, we can show you why it was wrong, address that when you go forward, but they're still allowing Shell Impact to nevertheless at least continue the application for a renewal of their right. Both sides, ironically, have said that they are contemplating appeals to the Constitutional Court because it's not sufficient for either side.
Okay,
so we will have to wait to see.
But more of it to come, Tauriq. Thank you for taking us through this one. It was rather complex, and thank you for unpacking it so succinctly for us. That was legal writer for Business Day. That's Tauriq Moosa.